Welcome to the Franchise Company First Friday for November. And amazingly, we're now 11 months through the year for our First Friday events. We have got a lot of new people enrolled, signed up for the event today, which is great. So just to reiterate that these events are held every month and they're all available on our website to view recordings, and they're very much designed to add hopefully additional information, good knowledge, share good practice, etc. across the franchise industry and sector. So anyone and everyone involved in franchising is welcome to join these events. They're normally on the first Friday. This isn't the first Friday in November because last Friday was the BFA conference, so we avoided the date to avoid any clashes. And delighted that this month our guest is Simon Wise, who has been in franchising not quite as long as I have, but for a significant period of time. I think Simon and I first met when he was assistant director at the British Franchise Association.
Yeah,
And
yeah,
then,
long time ago.
yeah, as I tell his story, moved on, became a franchisee, now runs a couple of businesses very much focused in the franchise sector. And again, because of the longevity of the time that he's been involved, Simon always joins our events, which we're very grateful for, and always has a significant positive contribution to make. So I'm going to hand over to you, Simon, now
Thanks.
to take us through the session today about franchise network
Brilliant.
management and how mediation can be involved in that.
Yeah, fantastic. Okay, here we go. Where is my slideshow screen? Can everybody see that?
Can see
We got it?
see the overview, but not the there. That's it,
You got
Simon.
it, yeah?
Yeah. Do you want to do
Excellent.
a quick
Okay.
intro to yourself, Simon, for
Yeah,
the
sure. Why not?
new
Indeed. I'm
people?
my name's Simon White. I'm the very proud owner of a business called Franrec. And what Franrec does is we are our main reason for being is that we recruit staff and executives for franchisors. That's all. That's we only recruit for on the franchisor side. Have been doing that now since 2013. Prior to that, I spent 8 years as a driver hire franchisee. Um, I bought a underperforming resale in the North London area. We turned it around, and then we took an exit from that in 2013. And then to go right back to the beginning, my introduction to franchising came through the work when I started work at the BFA as the business services manager, responsible for again recruitment, membership recruitment, and then I was very fortunate to be elevated to the position of deputy director general and took on a lot more strategic and standards based work as well. So yeah, I've been in and around franchising for since 1997. I'm not going to call myself an expert because I think that's probably a widely used term. I love franchising. I'm passionate about franchising. I know a little bit about it, but I'm always looking to learn, and I think that's really important. And I have a very inquisitive mind, as Julie will tell you. Sometimes a bit of a nerd-like obsession with franchising, and what we're going to talk about in the first part has been keeping me awake at night for the last few weeks. So that's pretty tragic, isn't it? But it's true. And I recently qualified as a mediator, and what I wanted to do today was really talk about mediation and why I think it's so really important that franchisors, franchisees look to resolve any disputes through mediation rather than litigation, because the litigation is exceptionally destructive. And I want to really put in a stake in the ground for mediation today, and that's what I do. But as being a mediator and obviously and working very closely to the in the franchising sector, you do get a little bit hypersensitive to things as well, and things and the way people do things and the general vibe around the industry, I guess. And sometimes that causes you to have a little bit of a think and think, hang on a minute, is that really the right thing to be doing? Is that the direction that franchising needs to be going into? Um, and then the context of mediation and making sure that the industry remains harmonious and self-regulatory. I'll put that in there. I'm not here going to talk about the arguments about regulation, but if we're going to keep franchising alive as we know it and thrive and continue to thrive, then I think that mediation is a really important part of it. But equally, I think it's only my responsibility to share some of my experience and maybe point out things that I get a little bit worried about in modern day franchising, which, with my mediator's hat on, potentially could give rise to problems downstream. So that's a download of a load of information. But what I want to do is I want to talk about mediation today, but I think it will be remiss of me not to flag up something that is just giving me a little bit of concern at the moment. And I'm not a lawyer. I'm just somebody who's passionate about franchising and somebody who's been around it a while and is fiercely protective over franchising. But one of the things that's occurred to me recently is really the evolution of franchise support. And when I joined the franchise community back then, it was all about field representative with a clipboard, operations focused on compliance, policing the brand, and making sure people did things properly. And thank goodness, modern day franchisee support is a lot more modern than that. In my role as a staff and exec recruiter, my most popular role and the thing that keeps us busy more than anything else is recruiting in the franchise support arena, but specifically for the business performance manager, the individual that is very much at the coalface and the individual that supports franchisees and helps them drive their business. And it's testament to modern day franchising that good franchisors invest in that resource that they could bring in and really support franchisees' growth. Now, it's not a philanthropic exercise. Look, at the end of the day, if you've got somebody in the field that's driving performance and driving growth of your franchisees' businesses, you are obviously increasing the revenue that you earn as a franchisor through management service fees. But the focus has changed, and I think that's the point that I wanted to make here, that the support has elevated from oversight to partnership. And I will flag up one of my other biggest concerns at this very early point. The use of the word partnership in franchising does worry me a little bit, and I'll go on to explain why that is in a minute. But I want to talk a little bit, just have a little bit of again, in the context of disputes and managing risk, to talk about the franchise support function. Because the big picture is evident that franchise support drives franchisee satisfaction. It ensures that consistency. It provides the validation that fuels the recruitment process and provides long-term profitability. And I love this quote, that support isn't just part of franchising, it is franchising. And that's the reason that I chose to go into franchising, was because I knew that I would have the support of a very well-established brand and a system and a way of doing things, and people there that had a vested interest in making sure that I'm successful. So I'm not here to teach you about franchising and franchising support, but what I want to do is focus on the support element, which I see evolving, but equally see some red flags around it as well. And I just wanted to talk to you about that a little bit. So please, and by all means, interject at any point and ask any questions, because I think this is a discussion that will be really, really worthwhile having. I think with franchise support, the goal is, and this is really important, is to empower franchisees to run independent businesses while protecting brand standards. And that's the ethos, that's the essence of behind support. And support should enhance the franchisee's business, not replace it or control it. And I think this is where I have most sort of worrying concerns about modern day franchising, or certainly some of the things that I'm seeing in the marketplace at the moment. And the question I want to ask is, can we go too far for what, after all, is a business to business relationship? So, supporting franchisees is vitally important, but I think the modern take on support has been pushed in a little bit of a direction that is a bit worrying to see. So what do I mean by that? Well, what I mean by that is that we are seeing the relationship between franchisor and franchisee maybe moving more towards a franchisor employee relationship than a business to business relationship. I see um, I see aspects of franchise support which is very controlling and very almost micromanaging of franchisees as well. I see franchisors who the way that they implement their systems or what they call support is a very controlling environment. Um, and as a franchisee, you know, it's difficult to see why how they're independent from the main franchisor and how they are not all part of the homogenized uh, entity, if you like. So, and I think it's a bit worrying. I think that's a bit worrying from somebody who's very mindful of risk and things that could potentially harm the brand franchising and lead to disputes. Um, so I think modern day business support is being encouraged in a certain direction. There are some brilliant practitioners out there about training and a lot of franchisors are being encouraged to dig even deeper and look at the psychology behind the franchisee and adapt their support mechanisms for doing that, which I think is great. But I also think that it is maybe going into a territory that is can be seen as a little bit dangerous and heightening the risk in certain aspects. So, as somebody again who's very mindful of that, I ask the question, can we go too far in what we're doing? Are we sometimes blurring lines between the franchisee, the franchisor relationship, and maybe doing things that are maybe employing more of an employee or even an agency relationship? And I think that brings with it some risks that everybody needs to be aware of. The other point I wanted to make was that and again, this is something that is very, very logical, that if you stifle a franchisees on entrepreneurship, if they feel that like they're being micromanaged, they tend to disengage, and that leads to weaker performance and higher attrition. And so I think it's really important to respect the independence of the franchisee entrepreneur. Um, One of the things, and some of the language that I see being used again, and one of the areas that really does concern me a lot is the use of the word franchise partners a lot. People use it to when they describe their relationship, and that concerns me a little bit. I think that well, it does concern me because it's not a partnership, it's not a business partnership by any means, and certainly the way that the franchise agreement is structured and the implications of franchising, it isn't a partnership. So. And I think it's really important that people's expectations are managed from the very start. And if we do that, then we're going to avoid disputes. And the last thing I wanted to say, or just an observation, is I think over support also creates over expectation as well. And franchisees start treating the franchisor like a safety net, which leads to claims or disputes if the help changes at a later date or stops. And so that was my preface. I mean, could I ask if there are any people that violently object to what I've said, or if they feel that it's not the appropriate representation to make, or something that you feel that you can understand and align to?
No, I think everything you've said there was really fair. It's probably speaking on behalf of ourselves, something we're working through at the minute, and finding that balance between implementing compliance policies and areas that are non-negotiables and doing that in a way that doesn't remove the franchisees' entrepreneurship. I mean, I think that's would be part of a bit of our journey at the moment. So it can be interesting.
Absolutely, absolutely.
It's a tightrope, it's an absolute tightrope, and I think it's different for every franchisee as that line and where that line falls. Are you creating dependency or enabling independency? And I think for it, different people respond in different ways to that, but we mustn't create dependency.
No.
Yeah, but I mean, Chris, you've been around franchising for probably longer than I have. I mean, it is quite clear.
Don't know about that, but yeah.
And you've been a franchisee as well. I mean,
I've been a franchisee, and yes, and I've Julie, I've read documents that Julie's probably seen, which were absolutely about compliance and tick boxes and Has the franchisee done this? Has the franchisee, the franchise visit was something that was feared, by the franchisee themselves. They didn't want to be checked up on by head office. And even that head office, we prefer to talk about national office, and it's in language terms, isn't it? I mean, you're talking about partnership, and I agree with you what you say about partnership, that there is a real danger in that. But franchise partners is something that people talk about, isn't it? Is that a softer version, or is that not? Is that still alluded to the big A partnership? It's again, people's interpretation
like I
is
said,
different.
it might sound a bit petty and a bit nerdy, but again, I just when you look at stuff that's in the public domain where individuals are franchisees are complaining about their treatment, we always thought we were partners. We always thought we were franchise partners. It's a partnership. Well, it isn't. I mean, and that's the problem. You can call it a franchise partnership because that will help you in the process of recruiting franchisees, because everybody feels like they're singing, they're on the same level. But my beef with it is the reality of the relationship is not a partnership, and I think, and I don't think it should be either. I'm a great believer in the weight of the power being in the hands of the franchisor. It's their brand, it's their system. As they were building that network, think of every time that they had to pay for their mortgage on their credit card, for example, just to keep this dream going. And now you're in the position where you're just licensing it for somebody else to use. So there's quite an emotional attachment to the fact that the balance of power has to be with the franchisor. But look, like I said, I'm not here as being the all-conquering expert on franchising, but as somebody who is very mindful and quite acutely aware of things that potentially could lead to risk in a relationship. I just think it's appropriate to identify that, and I think franchising is a fantastic opportunity. But I think in recent times, maybe we have lost sight of some of the pioneers about how to behave as a franchisor. And yes, you need to be warm, open, friendly, and cozy, but equally you have to be mindful of what you need to be as a franchisor as well. And sometimes that is strict, and sometimes that is separating yourself out and not always wanting everybody to be your friend and engaging in that basis. So it's not there to criticize, it's there as an observation. But I just feel that if we go ahead 5 years and then we look back, and in 5 years time we look at the UK franchising as a heavily regulated environment, and we think to ourselves, well, how the hell did we get here? As a regulated environment, we're not seeing higher performance in franchising. We're not seeing more people coming into franchising. We're not seeing fewer disputes in franchising. You think, well, how did we get here? How did we get to a point where we are now regulated in the industry and by people that are not franchising people, but they're by politicians and regulators. And I think I don't want to be in that position where we say, well, look, we have to put our hands up as people in the industry. We played a part in that because of how we operate. But
I think, Simon, picking up on that point about, if you like, looking back, we had a First Friday, possibly earlier on this year, which is on the website, from Melvin Lusty, who some of us will know and recognise as the franchisor that developed Rainbow International and was very successful and, sold out for a significant amount of money, and his franchisees. A lot of them were very successful as well. When you listen to Melvin, the tone and the methodology wasn't warm and friendly, and it certainly wasn't fuzzy. It was friendly in terms of, his brand, his way, his business, and he had very high expectations of his franchisees and very clear roles, for them to follow, basically. But it was very clear and it was very direct in terms of what the franchisees were expected to do and basically how the relationship was set out, and ultimately that worked. I think in terms of the tone for today, maybe not, but there's a lot of good stuff in there that can be adapted. And for me, the key is it's not dependency. It's, for me personally, from a high level modeling perspective, it's about interdependency. that the franchisor can't be successful without the franchisees can't be successful with the franchisor, but it's the interdependency of the system that's developed and the model that's put in place to begin with that either builds the building blocks for success, or don't if they're not there, basically. And what I have seen is franchisors consistently creating dependency by doing too much in the early stages and not enabling and training the franchisees to do it themselves, doing it for them and continue doing it for them, in which case expectations, change, and that's when problems start to arise.
You might come on and talk about this later, Simon and Julie. Most of our franchisees, in fact, every single one of our franchisees has not been in franchising. So they tend to come from either being members or just, they've kind of seen an advert and on SEO, got to our website. And so we've just got a new franchisee onboarding at the moment, and she's from the corporate sector. And as we're going through, she's like, "Well, do I need to check this with you? Do I need to check that with you?" I'm like, "No, no, no. It's your own business. You just need to manage that business." But I just wonder if there's a way of quickly and easily kind of inducting people who are new to franchising into what franchising is.
Yeah, I mean, I think, to be honest, Helen, I think that goes back to recruitment. I think during the recruitment process, that has to be very clearly, that relationship has to be clearly established during the recruitment process, so people can select, you can select, self-select whether it's right for them or not. And then in terms of the induction training, a module in the induction training to actually, again, go over roles and responsibilities and expectations to set the standards and the expectations at the beginning. Because as we all know, as you take people through recruitment and induction, they only hear a proportion of what's said.
I just wonder if there's something before that stage, though, before they're even onboarded, because what you tend to get, particularly with franchise, if they take the franchise agreement and then they take that to a lawyer who's not a franchise lawyer, which does sometimes happen, and then often lawyers will say, quite rightly, this is stacked in the favour of the franchisor. It's massively stacked, and it's almost sort of saying to that prospect, look, this is standard, like this, it has to be this way, this is the way that it has to be. So I wonder if there's anything industry wise that's a step before that just sort of says, here's your introduction, here's your induction, it's in a video, or whether there's anything that exists or could exist just to send on to people, just so you understand franchising before we go any further. This is not from us, this is from the BFA or whoever else. I just wondered if that existed.
Yeah, Natalia.
Helen, yeah, absolutely it does. So the BFA has a prospective franchisee certificate, which is basically some modular training on their website that prospects can complete in their own time, and then they get a certificate to say they've completed it. It's aimed to do exactly what you've described. So it just gives them information on what franchising is about, and it's general information about franchising, not specific to any brand.
Okay, brilliant.
Or any franchisor. So I think it was recently updated or is in the process of being updated. But I would strongly recommend that you have a look at that.
Brilliant. Thank you, Natalia.
I think also, Helen and Natalia, you can kind of disagree with this. What some lawyers are doing now is, in addition to the agreement, they're producing, if you like, almost an overview document, which goes out with the agreement, which basically describes the functionality of the franchise agreement and covers the points that you've said, that actually it is heavily weighted in favour of the franchisor and the reasons for that. And ultimately, and again, from a personal point of view, I've said to many franchisors, in terms of dealing with franchisees, you can almost tell a franchisee, if they don't go to a BFA affiliate, they will be advised not to sign that agreement, because the BFA affiliate won't understand what's in the agreement and the reasons behind it. And actually, again, from a recruitment point of view, to some degree, that kind of works in your favour, because when they come back, they'll say, they've told me not to sign it. That's exactly what you said they were going to do. So again, you've managed their expectations to say you're not going to get the best advice by going to a non-BFA affiliate generally.
Yeah, Julie, just to add to that, exactly that. I think, just in terms of non-franchise, lawyers who are not experts in franchising, they won't be providing any of that franchise experts do. Part of my report, I always build in a summary about franchising generally, and I very much walk prospective franchisees through going, this is standard, and this won't be under no illusion, this is not going to change. And yes, you need to be aware of this, but this is this is standard in the industry. I think there's nothing, getting legal advice protects both franchisees and franchisors. And I'm a very big advocate of, I think all franchisors should insist that franchisees get legal advice at the outset, and from a BFA affiliate or somebody who's experienced in franchising. And that means, not just picked up a franchise agreement once 20 years ago, but actually, regularly does franchise related work, because that just protects everyone. The number of disputes that I see, I would probably say 90%, the franchisee didn't get legal advice at the outset, and then a dispute arises. Yes, obviously disputes arise when franchisees have received legal advice and are familiar with franchising, etc. But there are quite a few that could have been prevented or avoided if they had received legal advice at the outset.
Right. Happy with that, Helen?
Yeah, that's great. Thank you. Really helpful.
You're welcome. Back to you,
Super.
Simon.
Thank you very much. Thank you. So yeah, that was just a bit of an interlude. Apologies. I do apologise, but it's just an observation, and I just think that when we are talking about mediation and resolving disputes, I think there are things. The message here is there are certain ways in which you behave as a franchisor and a franchisee as well that can obviously create situations that you can see just causing problems downstream, and that was the point of the exercise. It's not to scaremonger or anything else, but in the area of franchise support, it's one of the things that I've seen, and again, one of the things that just raises my eyebrows sometimes when I think about, well, this is potentially going down into a dangerous path. But excellent. Well, let me just go into the meat and potatoes of why I'm here, really. But I want to talk about mediation, and I want to talk about why it matters in franchising, and it matters because it lends itself very well to the franchisor-franchisee relationship, and it's a very effective way of resolving issues and disputes that can take place. Equally, I just hate I hate litigation. I think it's it's, from a franchising point of view, it's the most expensive lottery ticket that you will buy, because you turn up in court and you don't know which judge you're going to get. You don't know how much they know about franchising. Are they going to be looking at this through the prism of the post office scandal? And not least, one of the biggest challenges I see with litigation at the moment is that, and my brother who's a lawyer, commercial property lawyer, who does a lot of the court work as well, tells me it takes 6 months just to get the paperwork drawn up now, and another 9 months just to get in front of the judge. So it's a very time-consuming exercise. So mediation for me is the logical option and the logical way to go forward if there are any disputes within the franchise relationship. The relationships can be preserved. It avoids lengthy, costly litigation, and we'll talk about the cost later. But it provides flexible, tailored solutions, reduces emotional stress, and really protects the brand franchising. And that, for me, is a really important part of it. It's protecting the brand franchising. It's making sure that, there's a lot of stuff going on at the moment in the background. A lot of it has been aired in social media and everything else. And I think we've all got a responsibility to protect the brand franchising. And if we can do that by keeping out of the courts, then I think that's the way forward. And there's also a lot of mindset, again, going back to franchisor mindset, that your agreement is bulletproof, and you can always use that phrase, oh well, we'll see you in court then. are you safe in the knowledge that you will succeed in litigation in the current environment, in the current climate? I don't know anymore, and I think it's really important that you have an alternative way of resolving disputes. So I'm a massive advocate for mediation. I mean, there are some key differences, and mediation's all about collaboration, flexible. There isn't, and this is something Natalia taught me. It's not a win-lose scenario. It's very much a win-win scenario for both parties. The speed of resolving disputes is there. 6 months to get the paperwork, 9 months to get in front of a judge. How long do you want a bad smell hanging around, for goodness sake? You want to get it sorted out, and mediation provides that opportunity to really get it resolved quickly. Cost is a massive factor as well in why I'm a huge advocate for mediation. You're looking at low to moderate costs versus tens of thousands, hundreds of thousands of pounds to have your day in court. The stress levels for all those involved are highly significant when you're looking at litigation, and through mediation, it's a much more comfortable environment to have a really open, honest discussion with both parties. And this is another thing as well. It's about mediation. When we conduct mediations, it's all done in a very confidential manner. It's not in the public domain. And again, that's about brand, reputation, resolving disputes. You don't want to have anything out there that's going to, cause concern both to your existing network or people looking to join the network as well. So here, very briefly, and I'm not going to go into a lot of detail here, but this is how mediation works. So a lot of the work is done behind the scenes at pre-mediation, where we get a lot of background information from both parties, find out, really dig deep into the issues and the interests and the concerns. And then when we're ready, we get people together. Now, most of it is now done on Zoom, for example. So we do a lot of Zoom calls. Zoom mediations, for example, so you can sit in the comfort of your own home or the comfort of your own office and not be intimidated by those sessions. But the first thing we do is we have a joint session where we encourage everybody to bring their issues out into the public domain and share those issues with each party. What the key issues are, what the interests are, and what the individuals are looking to gain from the mediation. And we then break off into private sessions where, as a mediator, we meet individually with each of the parties and flesh out the real issues, and that process of mediation, and we go backwards and forwards between individual parties, and everything that's discussed in those private sessions is strictly confidential. And eventually we get to the point where we feel as mediators there is an agreement to be had, or in the zone of potential agreement, that we get the parties back together in a joint meeting, and we can draft an agreement which is a legally binding document, because that's the important thing, isn't it? When you do have a dispute, or you have something, you need to make sure it's documented and everybody agrees to it, because that's the way you're going to resolve the problem going forward. The role of a mediator is very much a facilitator. We're independent facilitator. We're not a judge to tell you that who's right and who's wrong. We listen and manage conversations. We focus on interest and not blame. And we ensure fair and respectful dialogue. We give everybody the opportunity to have a say, to have their side of the story. And if you compare that to a court hearing where you've got a very ambitious lawyer or a barrister that wants to go down a particular path, how many times can you feel frustrated that you never actually had your say? Well, mediation is there to give everybody their opportunity to have their say. The success rate of mediation is quite significant and quite staggering. And one of the things that I learned very quickly when coming into the whole area of mediation was a high level of success. 90% of mediations prevent litigation. More parties, if they've got together and agreed and put together an agreement based on their own interests and their own discussions, parties are more likely to honour those agreements that they helped to create. and flexible solutions often meet the parties' real priorities. You know, what's really important to them, what is the most successful outcome that they can expect to get from the mediation. Here's the big difference with mediation and litigation. You know, for example, for mediation, you know, you're looking at £445 per party for a 4-hour online mediation session. That's VAT, of course. You know, compare that with the costs of litigation, and Natalia will bear this out, I'm sure. But you know, £250,000 plus legal fees per day. I mean, it's just astronomical. And also the costs of mediation are shared between the parties, which again incentivizes the resolution. You know, if you've both paid for a 4-hour mediation session, you're going to work hard to make sure that you achieve what you're looking for within that period of time. I think, like anything, choosing a mediator is something that one needs to be quite careful about as well. It's a very personal, it has to be a choice. I would encourage anybody that's looking at mediation in franchising to mediate franchise disputes would be to consider somebody who understands franchising, you know, and that's another advantage. If you've got people that understand franchising, I think that's a more effective way of resolving particularly a franchise dispute. People outside the industry are not too au fait with franchising. You know, we've seen that in court cases where judges have said, well, I can't see how an individual without any previous skills or experience in this business can come in and be successful. Well, we all know that's the essence of franchising, for example. So a mediator with franchising experience, and there are some good mediators out there with franchising experience, but you know, the BFA has its own panel as well, and the CMC has a directory as well where you can choose specialist mediators as well. But the key traits of a good mediator are independent, neutrality, strong communication skills, and also good listening skills as well. And again, this is something that, you know, with mediation, and again, I'm not going to take credit for this. This is something that came out of a show I did with Natalia, where she introduced something to me which was really quite significant, that the mediation can be used to resolve disputes between franchisees as well. And what are those disputes most commonly around? You know, is territorial disputes, and there are ways in which you can use mediation to get franchisees together to resolve those conflicts without involving the franchisor, and provide a resolution which can then be documented and agreed upon. You know, you can use mediation in workplace situations as well, to resolve problems and issues between key staff members, for example, or where there are some issues to be there. The key thing about mediation is it's there to maintain working relationships, and that's really important. Whereas, you know, how many times can you go through litigation at the end of it, see a sustainable working relationship between the parties at the end of it? You can't. At the end of the day, it's very destructive. And mediation provides formal agreements for future clarity. So, for example, when you have the franchisee to franchisee dispute around territory, you've got an agreement in place which is on the record, and there's no ambiguity when the franchisee is looking to exit their business or sell a territory to a new incoming franchisee, for example. Mediation isn't always optional. For example, you know, courts will encourage mediation before going into litigation. Mediation refusal can result in cost implications, and importantly, you know, most franchise agreements include alternative dispute resolution clauses as well. So mediation is very much part of the DNA of a franchise relationship already. And I think it's really important to use mediation, and until that's exhausted, until mediation has been exhausted, not to push forward into litigation. So really, this is just to leave you with some key takeaways. Mediation is faster, cheaper, flexible, confidential, preserves relationships and brand integrity. You know, why does it work so well in franchising? Because the relationship is very special. What brought you together is a very special relationship between franchisor and franchisee, and mediation is a very good way of reigniting those relationships and making sure that they can be sustainable. You know, it's not just an exercise that is, you know, it results in a legally enforceable agreement through documentation. And again, it's a win-win alternative to litigation. So I am again, that's my parting message to you all, is to mediate and don't litigate, because it's a very powerful tool that you can use in franchising, and we'll be delighted to support you in those endeavours as well. Thank you.
Thanks, Simon. I'm going to kick off the questions. We've got some questions in the thing, but I'm going to kick off the questions, and I'll direct it first to Simon and then to Natalia. At what point in the, if you like, dispute process, when you've got a falling out between franchisor and franchisee, whatever, is it appropriate to actually start mediation or bring mediation in? Because as we all know, you know, disputes, fallouts with franchisees are part and parcel of franchise management, and most of the time franchisors try to resolve those in-house by hopefully talking and communicating. But you don't want to get, I assume, you don't want to get to a stage where, you know, or do you wait till you're not speaking at all and then you call in the mediator? That's the question, basically.
Yeah, it's interesting. What are your thoughts on that, Natalia?
I was going to say, do you want me to jump in on that? Because it's actually it's funny you should ask this, because it's a point I just made on my notepad. I actually personally think it should be done a lot sooner than it currently happens. So you know, I like Simon said, you know, disputes get so disruptive because it becomes about blame, and it becomes you did this or you didn't do that. There's so much blame, and that's what really hurts the relationship and can break it apart. And so I feel like, you know, instead of instructing a lawyer, if you tried a mediator first, that could be a solution, because often disputes can be caused by miscommunication or misunderstanding. And if that is the case, then you stand a really, really good chance of resolving whatever the issue is. And even if there is a genuine sort of a bigger dispute that maybe goes more to the heart of the relationship, again, the sooner you get somebody independent, third party in, who just essentially facilitates that dialogue and conversation, the better are the chances that that can be resolved quicker.
Yeah.
And with, you know, less cost and you know, less damage.
Yeah, I mean, and that's really, I think the timing is everything. And, you know, you don't just get one shot at mediation either, do you? You can keep using it. You know, even if you don't achieve the result and outcome to start off with, you can still go back and revisit it again. You don't just get one opportunity and that's it. But I think early intervention is really important, particularly in, you know, from a franchisor's point of view as well. You know, you just want to make sure that, you know, these things are getting addressed in a timely manner.
Okay.
Absolutely.
And again, Natalia, should the route be that the franchisor goes to the lawyer, as in potentially the lawyer?
2:15 they've just said.
I think that's that you. Nikki, is that you? Done. I think we might be listening to you, Nikki. Should the franchisor go to the lawyer that's drafted the franchise agreement to have a discussion when they've got problems? Because what we would always do is try and reach a resolution, but as soon as anything looks as if it's really got the potential to go off the rails, we would bring the lawyer in at that stage to say, look, this is what's happening, this is what we're doing, this has been the email exchange, this is what we're proposing. So it's at a very early stage before, you know, any kind of legal dispute develops. So should that be the same route? But at that point, potentially the lawyer saying, now you need to consider mediation.
But this is what I mean, I suppose, Julie, is that it doesn't necessarily, you don't necessarily, it shouldn't be a lawyer's call. I mean, mediation as part of a formal dispute resolution process, as Simon said, if there is a dispute, the court will expect you to have attempted mediation before it can continue to a formal sort of court hearing. Or that is one of the questions they ask is, what have you tried in terms of alternative dispute resolution? But, and obviously getting legal advice is everyone's prerogative. There's nothing wrong with sort of going to your lawyer and saying, where do I, this is what's happening, where do I stand? And there are different types of lawyers. So, for example, I'm a contractual lawyer. I'm not a litigator. But that's not to say that, for example, when I wasn't in house or with my existing clients now, that I wouldn't say I get involved in disputes. I get involved in preventing disputes, and that could be that there is a situation. And I have a conversation with my client, kind of going, okay, what's the background? What's happening? What have you tried? And ultimately, my first question would always be, what's your ideal outcome? What is it that you're trying to achieve? Because, again, to pull on another point that Simon made, the beauty of mediation and the big disadvantage of litigation, I mean, if you go to court, you're going to get only one thing, and that's money. But money is not always what the parties want or need. So, taking things to court essentially means that it's really fallen apart. It's so bad. What you're going to get is damages. But, by what mediation allows you to do is resolve that, situation by being really creative and seeing what other what the outcome might look like, what are the options, and finding a way forward rather than, I suppose it's forward looking, isn't it? So to go back to your question in such a long-winded way, I would say, yes, you can turn to, yes, if you have a lawyer or a trusted advisor, yes, you can seek their opinion, but there's, if you can bring a mediator in, and now obviously that we have a pool of people who are trained mediators, I see absolutely, I only see the benefits of bringing them in as early as possible. So it should be, because also in costs, if you're considering if you think about going to a lawyer, well, the hourly rates sort of, £300 up. And when you consider that the cost of mediation, 4-hour mediation, is £500 per party, well, that buys you, value for money, a lot more and a lot more time. So what can you do in 4 hours? I mean, going to a lawyer would cost you a lot more. So I would always try mediation first. And if that doesn't help, then, you still have your other options open.
Yeah, and I think, again, for the benefit of anyone new on the call or watching the call, I would say 95%, if not 99% of the franchise sector, is against litigation, including the lawyers who actually make the most money out of litigation. Yeah. And for the purpose of anyone's benefit, John Pratt from Hamilton Pratt, who's, practicing, I wouldn't say specialised in franchise litigation, but they do a lot of work in the sector. He did a First Friday, probably one of the early ones we did, which was basically how to avoid litigation. So John, in his usual very dry style, takes us through the opportunities and the routes to avoid litigation. And again, that's there for everyone to view. But I'm going to go to one of the questions. Chris, you've got a question on the chat, which I'll hand over to you to.
Yeah, I mean, I think absolutely, John's words are echoing in my head, and everything's been said here. Nobody wants to go to litigation. Nobody, with respect, Natalie, wants to be paying £300 to £400 an hour to, for advice that's going to, effectively go nowhere. But there are times when I think it might be challenging to use mediation. It would be better to use mediation. But if a franchisee's left the business, for example, or post, and he's not following post termination restrictions, or you know, there's a debt accrued,
Yeah.
you know, for somebody who, you know, there's simple debt that needs chasing. But you know, one of the parties hasn't really got a vested interest in getting involved in mitigation. It's not in their interest to have those conversations. They're trying to ignore this and just, you know, just get away with whatever they're getting away with.
Yeah.
What's the recommendation in those circumstances? Have you got examples where this has worked, or?
Well, can I don't think you have anything to lose by going to mediation, even in that scenario as well. Like I said, I'm mindful of the fact that I genuinely think that, you know, a franchisor, gone are the days where you can go to a court hearing with 100% confidence that you're going to win.
Yeah,
Okay,
absolutely.
Because the ignorance around franchising and the franchisor franchisee relationship extends into the judiciary system as well. And we've seen that, and I can't stress this enough. I think, you know, what's happened with the post office scandal, for example, what potentially could happen with the Vodafone scandal. Who's to say that you know, all these cases aren't going to be viewed through those prisms? So I would say, for the sake of 400 or 500 quid, I can't see any reason why you wouldn't even think about mediation, even if you feel you've got a cast iron case, you know, post termination non-compete clause, which, you know, okay, it's a boilerplate clause, isn't it? It's a solid, but I would still say you are still running the risk of losing,
Well,
depending
famously,
on
you know, there's a very big brand
who
that spent an awful
yeah,
lot of money and
yeah,
ended up with a, you know, a difficult outcome
yeah, yeah,
on a
and
post
and and. and
termination.
and I would say again, the other advantage is the confidentiality. You know, this isn't in the public domain. You know, this is something that you can resolve between the two of you. You know, we see it now. How many ex-franchisees are there, or how many people that have been through litigation are so prominent in their comments around franchising, and are so prominent in their criticism of people like the British Franchise Association, and trying to, you know, so I would, taking all of that into consideration, I can't see a reason why you wouldn't use mediation in any circumstance.
And,
And
I-
you
and,
can,
I- and I suppose in reality, Chris, even if the offer of mediation isn't taken up, the fact that you as a franchisor have made that offer and it's been declined by the
Yeah,
franchisee, if you know, if you then choose to go to litigation, to be honest, and I hesitate to say you've ticked the box because you haven't done it to tick the box, but you've been, you know, you've been seen to be the party that's prepared to take that route.
I certainly. I mean, you know, advice from a lawyer is important in this. In this,
yeah, 100%.
it's having a lawyer have your argument for you
Yep,
that's
yep,
expensive. But you know, to offer mediation is really positive. And I'm just wondering about the incentive of that party to get involved, um, and whether there's any way of encouraging that in some way. And we'd like to mediate. We'd like to get, you know, and we feel obliged in some ways to do something as a franchisor or in certain circumstances, because again, you kind of almost set a precedent in not taking action. You give,
yep,
you know, carte blanche to other
yep,
people, you know, behaving in certain ways.
yep,
And it would be much better to be able to mediate with this person and achieve an outcome, which is probably that they, you know, follow the rules. You know, it's not always, you know, a 50-50 or a 60-40 kind of
yep,
resolution.
Yeah.
yeah.
So again, Simon and Natal, do you have to formally have an agreement to mediate, or could in that situation, you know, Chris has just said, could Chris, as an example, ask Simon to make an approach to offer mediation and in fact try and encourage mediation, or does that agreement have to be in place before Simon can be brought in or the
Yeah.
mediator can be brought in?
Yeah, you have to have a formal mediation agreement to enable us to act. But you know, the point here is there are a few conversations. You know, again, there's a lot of work that goes on in the pre-mediation phase as well, in terms of dialogue and talking to different parties as well.
Yeah.
But there has to be a formal agreement in place for the mediator to be able to act. You know, we have to sign. You know, we have to take account of non-disclosure, confidentiality, everything else that goes on into it. So there has to be a formal process there as well.
Okay.
I think the situation that Chris describes is really tricky and very challenging, essentially, where one party, you know, wants to mediate and the other one doesn't and is not engaging with the process. You know, that's really, really tough. And ultimately, with litigation, it's, at some point, one party has to make a call. So, it's dependent on somebody biting the bullet and actually issuing proceedings. Up until then, it's all just threats, threats, threats.
Yeah.
So you can spend as much as you want in terms of time and money threatening someone, but ultimately, if you feel that you've got a claim, at some point you would have to issue that claim in order to start the formal process.
Yep.
And at that point, that person won't have a choice. They have to engage, because if they don't engage, then you will get a judgment in default, or that's essentially what would happen, right? Hopefully, if the other person doesn't engage, you'll get a judgment in default, and and then you would still have to enforce the judgment. So it's not the end of the story. I think a lot of people think you start proceedings and that's it, but actually once you get the judgment, you then still have to enforce it. So it is at that point. So what I would say is, if the other side is not engaging and you have to take action, you feel that you want to take action, you have decided that you want to take action, then you will have no choice, but you will have to issue proceedings. And at that point, of course, that's where, again, mediation will come up as an option, because the court will say, have you tried mediation? So the other person, again, would be presented with that opportunity. And as Julie said, if they turn it down, then again, that goes in your favor, because they will be penalized. But of course, all of this said, it depends on the value of the claim, which court it's which track it's allocated to, because some of this does not apply to small claims, etc. So
and I think the kind of main message coming through it all is, if there's any disputes that do seem to be getting beyond internal resolution, the sooner that the experts or some advice is taken externally, the better, before things really start to.
I think, and also, just if I could, I just want to go back to my original point as well about franchisors and how they behave. As I said, just think about. I think there is an opportunity for some mindset checking in terms of franchisor as well, in terms of how they behave and what they should and shouldn't be doing. And I think some of that is getting a little bit blurred and a little bit. I'm not saying let's go back to the old school days of franchising that is all about clipboard and pen and policing, but some of the principles under which some of those traditional franchisors were built upon, I think people had a much stronger appreciation back then about what it takes to be a successful franchisor and what mindset you should be having and how you should be conducting yourselves.
Interestingly, Simon, Ken Roston, who's on the call today, who's obviously co-partner in the franchise company, was one of the directors of Pontypridd when I first joined, and was involved with the development of Poppies. And I always remember him saying, because Pontypridd did have a reasonable number of disputes with their franchisees for various reasons, and I always remember him saying, always give the franchise, always leave the door open in terms of continuing a discussion, and always give a franchisee the ability to leave with their head held high and with respect. If you back someone into a corner, there's only one way out, basically. So for a lot of people, what Natalia was saying in terms of, yes, it's about the money, but there's also other factors, and one of them is the ability to retain your self-respect and leave with that self-respect intact to some degree, basically. And again, in terms of kind of managing disputes, that's something that's always, or managing problems, that's something that's always, sat with me, basically. And
I think there's a role for the, sorry, just one other thing. I think there's also an important role that advisors play in this part in there as well. Some people come into franchising on the franchisor side quite naive, and I think that's a lot of it is down to the advice that they're getting, which we all know as a BFA advisors is quite concerning sometimes.
Yeah, indeed, that's right. So we're coming towards the end of the session, and we'd like to give Simon a big thank you for the information that he's given and shared with us. And there's Simon's details, obviously, for anyone who wants to make contact either for recruitment or to talk about mediation. Neil did ask a question about getting information from franchisees, in a very early stage, and how to collect that and get feedback. There is a QR code on the screen. I'd like everyone now to get the mobile phone pointed at that QR code and leave feedback on today's session, please, which takes about 30 seconds. And that's the system that Neil has developed called Gather, which we use, and we use with our clients to obviously gain feedback from the systems today, but also get feedback from franchisees within the network to try and really, identify any problems at a very early stage, get feedback from franchisees, and take appropriate action about that feedback before anything goes really badly wrong, basically. So I'd like everyone just to scan that, take the information, and then as we are now approaching the end of the year, we have one First Friday session left for December, which is on Friday the 5th of December, normal time 1 to 2 p.m. And the title is Developing a Flourishing Franchise Network. Guests are Rachel Ray, who was the founder, developer, originator of Bright and Beautiful franchise network, which subsequently sold. And Rachel now runs a group, Chromia, which is about business development and expansion and scaling. And Rachel and I co-hosting the session together. And to some degree, it follows on from what we've been discussing today, which is all about the franchise management aspects of the network and how to develop a network that's hopefully positive, flourishing and successful, both for the franchisor and for the franchisee. And I guess to some degree, large degree, if you've got successful, happy franchisees, then the need for mediation, litigation, disputes is going to be minimised anyway. Because it is the last session of the year, everyone is invited and welcome to come along with appropriate Christmas jumpers, Christmas, garbs, itinerary, etc. As you so wish. Christmas puddings, Christmas cakes, you name it. You can bring along tinsel, whatever you want, and that will be our last session for 2025, which is quite amazing and quite bizarre. But thanks everyone for coming today. Nikki, there was a question about KPIs, which we'll try and pick up maybe in the next session next month. So I have noted it and I am aware of it. We'll come back to it next session if that's okay with you. And thanks Simon again. Thanks Natalia. Thanks everyone for joining. Chris, using you as a great example of a franchisor, and have a good weekend, everyone.
Thanks, everyone.
Thanks a
Thanks,
lot.
everyone.
Thank you.
Thank you.